afternoon, and welcome to the Court of Appeals Wichita docket for March 11th. My name is Leslie Isherwood. I was appointed to the court in the spring of 2021, and prior to that, I served as an appellate attorney for the Sedgwick County District Attorney's Office for 22 years. And to my right is Catherine Gardner, who was appointed to our court in 2015. And prior to that, she was Chambers Counsel for a judge for our court as well as the federal court, and then also served in litigation in private practice. And Judge Bruns was to be our third today, but he is under the weather. So the IT folks here at the courthouse have worked some magic to have a live stream available to him, and it's also being recorded. So we will conference the cases together and come to a conclusion on the cases together. So you guys are the sole case for us this afternoon. And so I would ask appellate counsel to request rebuttal time if you so desire when you initially approach the podium. But otherwise, if you could please come forward and announce your appearances.
Lindsey from the Kansas Appellate Defender Office. Your Honor, with the court's permission, could I please request 3 minutes for rebuttal? Thank you.
Good afternoon. May it please the court. The state appears by Deputy District Attorney Jody Litvin.
It's okay. Thank you. May it please the court, Lindsey Cornegay. My client appealed following a jury trial where the top charge was burglary to a vehicle. Unless the court wants to direct me elsewhere, I was planning on spending my presentation primarily talking about the multiple acts issue, which is issue 3 in the briefs. I was maybe going to touch on issue 1, the mistake of fact instruction, if there's time, but primarily I was going to stick with issue 3 unless the court has other questions.
So I do have questions on the jury instructions when we're talking about our standard of review and when we get to the harmlessness. Normally for jury instructions that aren't objected to us here, we would look for you to prove clear error. But it seems like you're arguing for a different standard there.
Well, Your Honor, that's correct. I did brief a different standard. I was requesting the constitutional harmless error test, arguing that these jury instructions, although they were not requested, should have a constitutional harmless error test applied because they more properly set out the state's burden of proof in this case by outlining exactly what the state has to prove. But I know realistically, I'm imagining this court will apply clear error. So I would just argue that I briefed constitutional harmless error test, but clear error would apply here nonetheless for all the issues that I briefed. So yeah, I see your question, and I think I was a bit optimistic about the reversibility standard, but.
What authority would you direct us to as most persuasive for that change in that position?
Well, Your Honor, if I look at issue 3, that's the issue where I think we have the strongest argument for constitutional harmless error test, and that's in light of Ramos v. Louisiana. I don't think this court or any appellate court has yet addressed what we do with reversibility for a multiple acts issue in light of Ramos v. Louisiana, and that's the U.S. Supreme Court case that held there's a constitutional right to a unanimous verdict. And really, I think what started my thought process on that was looking at State v. Voiles, where it explicitly said we're not going to apply constitutional harmless error because there's no federal constitutional right to a unanimous verdict and no state constitutional right to a unanimous verdict. But Ramos v. Louisiana changed that. There is now a constitutional right to unanimous verdict. And Voiles had said, because this was an unrequested instruction and because there's no constitutional right at issue, we're going to apply clear error. But my argument is that's different now. And I've done some research even just yesterday prior to this hearing of trying to figure out whether any court has explicitly addressed this question for multiple acts. And I don't think there has been. There has been some kind of tentative discussion of Ramos v. Louisiana, but it's never quite made it into the reversibility standard for multiple acts. So I'm hoping we could get to that. I understand there's a lot more steps to multiple acts, and that's the final step, and who knows if this court will get that far. So I guess I would continue my presentation kind of on that theme of the other steps of multiple acts and maybe why we can get to that reversibility standard at the end. So there's 3 steps for the multiple acts. We have, first step, is this a multiple acts issue? And my answer to that is yes, because we have the act of Jessica Garza entering this vehicle with the intent to commit theft. And we also have the state's theory that my client, Lindsey Wabaunsee, entered into this vehicle, popped the hood on the vehicle with the intent to commit theft. And I'm saying there's multiple acts there because the core question of a multiple acts issue is, was there a unanimous verdict for this charge? And I can't say with certainty that there was, because when we're looking at the underlying act, 10 jurors could have believed that this was an accomplice theory of liability. 2 jurors could have believed that my client was guilty in the principal. And so we don't have a unanimous verdict for that underlying act. And that,
But was the accomplice theory really argued or instructed on?
Your Honor, so in instruction 3, I think it was instruction 3. Hold on 1 second here. So instruction 3, you do have the aiding and abetting instruction. That was an instruction right before the burglary elements. And as the state pointed out rightfully in their brief, in closing arguments, you did have the state talk about the burglary elements and say, my client was guilty because she entered the car, she popped the hood. So in all fairness, the state was talking about that a bit in closing arguments for the elements of burglary. But my argument is that the totality of the state's closing argument was on an accomplice theory of liability. They were talking about Jessica Garza and Lindsey Wabaunsee working in tandem, that it was just an accomplice theme throughout their closing argument. So even though the state did reference the elements of burglary and kind of my client acting in the principal, just the totality of the closing argument was accomplice, it was getting muddy, it was getting confused, and you also had this aiding and abetting instruction right before the burglary elements. So I think this case gets especially confusing because there's 5 different charges total, but 3 charges. First one was burglary to a vehicle, and the state is saying maybe that was a principal offense. And then you have criminal damage to property, and the state suddenly switches to accomplice. And then you have theft, and they're switching to accomplice still. So it gets kind of muddy there what the state was going for, and especially with this aiding and abetting instruction, it wasn't particularized to any charge. It looks like it applies to all the charges, frankly. So I think that's the issue. Sorry, did you want to speak?
No, I was waiting for you to finish.
Sorry.
But with multiple acts, you need to have 2 distinctly separate acts. Do we have that here? I mean, where's the fresh impulse from the end of one to the beginning of the other?
Well, Your Honor, I would argue that the evidence that came out at trial suggested to me at least that Lindsey entered the vehicle to pop the hood to change the battery. While she was changing the battery, Jessica Garza then enters the vehicle and starts trying to take things out of the vehicle. So my argument would be there are those separate impulses that kind of delineate the acts. And I guess, separate or a fresh impulse kind of references that 4-part test of multiple acts. And I think we do have multiple acts when you look at that 4-part test that does reference fresh impulse. But I think even regardless of that test, that's not something that necessarily needs to be applied. I think we do have multiple acts with that 4-part test, but I guess there's some case law that says that's not the end-all, be-all. So that would be my argument, is that we have Lindsey entering first, and that's delineated from Jessica entering after Lindsey's already in front of the car, popping the hood, working on the car. So that would be the fresh impulse, the separate impulse for that 4-part test.
So if we don't apply the 4-part test, what analysis would we use in its place?
Well, Your Honor, could I have a moment to look at some case law here?
And while you're looking at case law, my perception is this is the first case I've seen where somebody argues multiple acts based on acts of 2 different people, or a fresh impulse based on the thoughts of 2 different people. So if the case law helps with that too, that'd be great.
Sure. Let's see. Judge Isherwood's question. So the test that I'm looking for, if we don't apply the 4-part test here, is State v. Allen. It says the critical issue is unanimity or the verdict. And that's a case where they're saying there is no single test for whether conduct constitutes one act or separate and distinct multiple acts. And this is a case where a defendant had crack in his pocket, crack in his house, and then he was charged with possession with intent to distribute. And there's the issue of this is all occurring at the same time in the same location. There's not really any separate impulse. But the real issue is that 2 jurors could have convicted that defendant based on the crack in his pocket, and 10 jurors could have convicted that defendant based on the crack in his house. So it's like the 4-part test doesn't quite apply there. They're saying, yeah, they recognize the 4-part test, but there's certain circumstances, certain situations where that doesn't necessarily apply.
What is the site for Allen?
It is 290 Can 540, and then the pin site is 544, and that's from 2010.
Thank you.
I'm sorry, Judge Gardner, could you remind me of your question?
Well, this is the first case I've seen for multiplicity, I think, that argues multiple acts based on acts of 2 different people and fresh impulse based on thoughts of 2 different people. Do we have any case law that addresses that?
Well, Your Honor, there is some case law about homicides where you have 2 co-defendants. I didn't cite it in the brief. I actually have it on my phone. I could maybe look it up while the state's going. It's on my phone. You have these homicide cases where it's 2 defendants and 1 defendant is arguing multiple acts, but the Kansas Supreme Court held that multiple acts didn't apply because there is 1 victim, 1 deceased person. So I didn't quite cite those in this case. It didn't feel quite applicable, but that was to answer your question, that was kind of a similar
That's
case.
the closest, maybe.
Right. But it seemed like it different from my case where you have these 2 separate acts that could maybe constitute burglary, but with the homicide case, it was just 1 killing, 1 deceased person. So that was kind of the distinction why I didn't necessarily cite it in the briefs. I guess I'm probably getting close to the end of my time. I think I would just conclude my initial argument there and turn it over to the state. Thank you.
That will leave you 6 minutes for rebuttal.
Thank you.
May it please the court, the state appears by Deputy District Attorney Jody Litfin. I'll go ahead and start with issue 3 as well. The way the state briefed this was considering this to be a jury instruction issue, considering that the defendant did not request a unanimity instruction, putting us in, if this court finds this to be error, the defendant's burden is to prove clear error. So we briefed it as a clearly erroneous standard of review. We believe that's the appropriate standard of review for this court. And that to the extent that the appellant cites other case law from the Kansas Supreme Court saying that it's not applicable, I mean, this court is bound to whatever the Kansas Supreme Court says. So until there's a case that changes that standard, I think that we're in clearly erroneous, I don't know if it's called a standard of review, but clear error standard.
So you don't buy the fact that Ramos versus Louisiana was decided should change all that?
I don't think until the Supreme Court weighs in that this court should do anything different than treating this as a jury instruction issue. or the clearly erroneous issue under the current jury instruction standard. So our position is that this is not multiple acts. As this court knows, the jury must unanimously agree if there are multiple acts on which specific acts constitute the crime. The state went through the 4-part test because there was no jury instruction, or there was no unanimity instruction given here. So first we have to determine whether the conduct involved was multiple acts or was it unitary. And under that 4-factor test, I think both parties agree that the acts occurred at the same time, at the same location. We disagree on whether there was an intervening event and whether there was a fresh impulse. To the defendant's claim that Ms. Garza committed an intervening act when she got into the passenger seat of the car after the defendant had popped the hood, I guess the state finds that to be questionable given the evidence that was presented. The way that the state read the evidence was both women got into the car near the same time or at the same time. Ms. Wabaunsee got in the driver's seat to pop the hood, got out, got under the hood to start working on the battery, while Ms. Garza was in the passenger seat going through the contents of the car and trying to get the radio out with that tool. So
I'm sorry to interrupt you. So they entered separate sides. So it's not as though she exited the driver's side and Garza swooped in and replaced her in the driver's side. They were opposite.
That's my understanding, Your Honor, of the evidence. The way that I read it is they both kind of got at the car at the same time. And, of course, the state's position is with the same intent to permanently deprive of the battery and those other contents of the car. So we don't believe that it was an intervening event, like Ms. Garza got in the car several minutes afterwards, or the way the state reads the evidence altogether is that they got in the car at the same time. So we disagree that there was an intervening event. Additionally, we disagree that there was a fresh impulse that motivated some of the acts. While the defendant claims that Ms. Garza got into the car with a fresh impulse to steal the radio, our position is that both women got in the car with the intent to steal something from the car. Ms. Wabaunsee got in to with the intent to commit a theft, or, as Ms. Garza put it, remove the valuables. So I think she testified about cleaning out the car. I don't have it right in front of me, but getting the valuables out of the car, taking all the things out of the car, and Ms. Wabaunsee's job was to get the battery out of the car. So I don't believe that there was a fresh impulse with just Ms. Garza's intent to steal the radio. I think they both had, or it's the state's position, that they both entered the vehicle with the intent to commit a theft. So we disagree that there was multiple acts here under that 4-part test. But if this court disagrees and finds that there were multiple acts, we would alternatively argue that the state elected, as Your Honor was saying in closing argument. Prosecutor statements made during closing confirming a single incident is the functional equivalent of an election by the state. And here, when talking about the burglary, after the recitation of facts, the state talked about the specific instance of Ms. Wabaunsee getting in the car, popping the hood, getting out of the car to take the battery out of the car. So we would argue that the state elected if this court finds that there were multiple acts and that this election was the functional equivalent, of having this unanimity instruction because the state told the jury what acts it needed to find to commit the burglary. And then the third sort of alternative argument the state makes is that if the unanimity instruction was legally and factually appropriate, reversal still not required under the clearly erroneous standard because the defendant here presented a general or a unified defense. So her defense was, as in issue 1, I had permission to be in this car. It was a mistake of fact. I got the wrong car. This was Lacey's car. We were there to take the battery out. She asked me to change the battery out. And just presented this general denial of any wrongdoing. And under the case law, when a defendant presents that sort of defense, reversal is not required even without a unanimity instruction. So we would argue that for any of those alternative reasons, this is not reversible error, even if the court does find that there is multiple acts. And that the jury, because the jury rejected her defense, her unified defense, there was no error here. I'll go ahead and touch on the prosecutorial error argument as well. In those types of claims, this court looks at whether the comments by the prosecutor were outside of the wide latitude or were they error, first of all, and then did those improper comments prejudice the jury to deny the defendant a right to a fair trial. The statements that are claimed to be error here are during closing argument after the prosecutor goes through the recitation of facts and states what both Jessica and Lindsey admitted to was that they were both at the Dodge Stratus on June 2nd, 2021. They both went into the car, they both got inside that car, and they were both intending to take stuff from that car. And the defendant here argues that that was a misstatement of the evidence when the prosecutor claimed that the defendant admitted to Detective Julian that she intended to take items from the car. I think that the state's argument here is just a matter of arguing whether these facts prove that she had the intent, that she entered the car with the intent to permanently deprive or to commit a theft, or not. So I don't think the state's position is that this is not a misstatement of the evidence. It's just simply arguing what the defendant said and Ms. Garza said. They both agreed that they got into the car. They admitted that they were getting into the car. It's just the reason why they got into the car. So taking this this evidence and just simply arguing what avenue, like our theory of the case versus the defendant's claimed defense. So we don't believe that these were inappropriate comments or error and not a misstatement of the evidence, since really both women agreed that they admitted that they got into the car. It's just, did they have permission to get in the car or not? If this court does find, however, that this was a misstatement of the evidence, we would argue that this was harmless error. It's our burden to show that, and we think that we can. First of all, this jury was instructed in instruction number 1 that standard instruction statements, arguments, remarks of counsel are not evidence. Statements, arguments, remarks of counsel are intended to help you in understanding and the evidence and applying the law, but they are not evidence, and any statements that are not supported by the evidence should be disregarded. That was in jury instruction number 1. We presume that the jury follows the instructions, so we should presume that they follow that here, and advised them that any statements not supported by the evidence should be disregarded. And then secondarily, Sherman talks about the strength of the evidence. So I think here the strength of the evidence also supports that this can be harmless, because the defendant and Ms. Garza were caught attempting to remove the battery, the radio, and other items from the car. When the victim's mother came up on them, asked them what they were doing, they both said, or Ms. Wabaunsee said, well, this is Henry's car, and I'm getting the battery out. Ms. Priest knew that she hadn't contacted anyone named Henry, or that she didn't know these women, and so instead of hanging around to see, after Ms. Priest called law enforcement, the defendant and Ms. Garza left, instead of just trying to clear up this whole misunderstanding. They took documents from the car, they were pulled over, and the defendant immediately asked, was this about the car earlier? The truck that she was pulled over, her truck had numerous tools used to break into cars, and then when they were interviewed, both women essentially said, well, she knew Lacey, but no one had any contact information for Lacey, and I think there's a reasonable inference that this Lacey person doesn't exist, that they were both using each other to know Lacey, and that all of this evidence put together is strong evidence to show that the defendant committed a burglary and a theft, criminal damage to property, and the drug offenses as well. So we think the strength of the evidence here can help show harmless error as well as the jury instruction. I don't have any further presentation unless this court has specific issues on any of the remaining issues. Thank you.
I would begin my rebuttal with, it's issue 4, the prosecutorial error issue. I'm going to read the closing argument one more time. What both Jessica and Lindsey admitted was that they were both at the Dodge Stratus on June 2nd, 2021. They both went to the car, they both got inside the car, and they were both intending to take stuff from that car. In my reading of that, that was a misstatement of the evidence because Lindsey continually denied that she was intending to take stuff as part of a theft. I think the prosecutor's argument is leading the jury to infer that Lindsey admitted she was intending to commit theft and intending to take stuff as part of a theft, not as part of changing a battery, as part of an illegal act. And again, that would be a misstatement of the evidence because Lindsey never admitted to taking anything from the car, never admitted to any theft. She was consistently saying that she was there to replace a battery. There was 3 interview videos with Lindsey. Maybe interview is not the right word to use. There's 2 body cam videos in which officers talked to her and she was giving statements. And then there was 1 longer interview video. And during none of those interactions did Lindsey ever admit that she was taking things for the purpose of theft. It was always just that she wanted to replace that battery.
Did the jury were they able to see those videos?
Yes, Your Honor. But again, I think this goes to the critical question at trial was she there to commit a theft, or was she there to change this battery? And although the jury could see the evidence where Lindsey was discussing these things, I had to watch the video multiple times to see whether Lindsey actually admitted to taking anything. So I think for the state to say, yeah, she admitted to taking something, I don't think that is harmless error, because that was the critical question at trial. And you have these long or you have these kind of long videos sometimes where you can't quite remember if someone did or did not admit to taking something. I had to watch it multiple times. I watched it just yesterday just to make sure again. So I do think the state's comments did amount to error that requires reversal, because the comments that they make have a kind of special effect on the jury, a special impact. The jury is inclined to believe what the state says, even if there's some evidence to the contrary. The jury listens to the state.
But wouldn't that make every state's prosecutorial misstatement reversible error?
No, Your Honor, it wouldn't, and that's a fair point. I do think it is reversible error in this case, again, because those videos are long. It's hard to remember whether Lindsey did actually admit to taking anything. And also the other evidence was that Lindsey had an extra battery in her truck. That battery did not belong to the owner of this vehicle. The owner of the vehicle corroborated that by saying the battery was never stolen. So Lindsey had this extra battery in her truck. She had tools with her. They checked the tools weren't stolen. She had her testimony that she never intended to take anything. So I do think this amounts to reversible error. Maybe not in every case where, the prosecutor maybe misstates something a little bit, but in this case, I do think it rises to reversible error. I guess moving along, I did have some cites for that question that you asked about, Judge Gardner, about when you have multiple defendants, maybe multiple defendants, but with one murder victim. There's State v. Sprague, that's SPRAGUE, 303 Can 418 2015, and State v. Maddox, MATTOX, 305 Can 1015 2017. And again, those cases found no multiple acts just because there is one victim in that case.
Did you say Sprague was 418? 303 Can?
Yes, 418. Judge Isherwood, I think I had looked at a case that you were the state's attorney for. I don't think it was any of these cases. I think it was a different case, but it's kind of similar thing going on there where there was, one murder victim. But I guess just to conclude this argument, I am asking for this court to, if we get to the reversibility inquiry of the multiple acts, to maybe consider the Ramos question of whether this changes anything. Ramos explicitly said there's a constitutional unanimous right to a jury verdict, and we had case law before that was Voiles that said we're not applying the federal constitutional standard because there is no federal constitutional right, and this is clear error because there is no federal constitutional right. So I think that's a legitimate question now in light of Ramos v. Louisiana. And I guess I would just wrap it up there and say thank you for your time, and I would conclude my argument. Thank you.